next speaker is Alex Roberts, Counsel for Linklaters. He's going to be sharing a bit about IP in China. So, providing some information there, understanding your rights, and hopefully avoiding potential pitfalls. Alex?
Thanks very much, Matt, and thank you for having me. Nice to meet everyone this morning / this afternoon, whichever time zone you are on. As Matt said, I will speak through some of the pitfalls, hopefully be able to give you a few tips on dealing with IP in the China landscape. Just bear with me 1 second whilst I switch to screen share. So hopefully that's coming through now. As alluded to, I'll start by just painting some of a picture of the landscape in China in terms of IP, and try and hone down on some of the specifics for the healthcare sector, and hopefully be able to give you some practical tips to take away. So if you listen to only one slide that I go through, please do focus on the last one. I think that will be a helpful slide to put beside your beds at night in terms of IP protection in this space in China. So to kick off, I think what was really important for myself as a lawyer that's been on the ground here in China for over 11 years now is just to dispel the myths that we sometimes get when we initially get introduced to clients and meet people that are coming or thinking of coming into the market, asking, is China still the Wild West for IP? I think that is still the perception for some, but not the reality anymore. China has been very focused since the 80s on building up IP protections in terms of laws and regulation, and that was very much accelerated as it needed to be for WTO accession in 2001. So now when actually we look at the IP laws, and you can see on the right hand side of the slide, there's a trademark law, a copyright law, a patent law, all of which have been amended in the last 2 years. We're really looking at quite a comprehensive IP protection landscape in line with what we might be used to in the UK or other markets. And indeed, China is a signatory to the Berne Convention, the TRIPS agreement. So from an international perspective as well, there are a number of protections there that China is signed up to. One point just to point out, China mainland is different from Hong Kong, is different from Macau in terms of the legal regime. So if you're thinking about IP protection in either of those markets, or indeed doing registrations, they are separate systems and need to be dealt with separately. So as I've alluded to, the three big buckets that we always think about in terms of IP, trademarks, patents, copyrights, translate through into the China market. So just to give a very quick overview of some of the key points, trademarks, as you might expect, logos, names that are implicit to your goods or service, but they need to be, in the first case, legal, so not already taken by a state organization, for instance, distinctive from other players in the market, and indeed not just a function in nature. So we're not trying to just trademark the shape of a good, for instance, rather than some extra distinctive value. What is really important, I can't emphasize this point enough in terms of market entry in China, is it runs for trademarks a first to file regime. So if you do not file before someone else, you're not going to get the protection. And this is really important when you're thinking of coming into the market, to actually think about already registering, or as soon as possible afterwards. Because if you get someone, a copycat organization, they could actually go ahead and see your highly competitive product maybe entering the market and trying to register the same trademark without actually using it. So first to file is a really important principle to follow. And in the China market, in particular in healthcare, and Gary touched on it in his video, we have an heavily aging population in China, some of who do not read English. So actually having a Chinese language trademark to capture the older demographic could be really important for you too. In terms of patents here, and not too dissimilar to international markets, it's really key to actually have technical features, technical means to solve technical problems. and to obtain technical effects, and that is what can be patentable, and you'll get the most IP protection for inventions up to 20 years, utilities designs of slightly lesser period, but this is sort of the golden IP right under the Chinese regime, similar to elsewhere. But again, first to file is key. In China, there's traditionally been concerns around confidentiality agreements being observed. And what is key when registering patents in China is making sure that there isn't not already public disclosure of the invention or whatever you want to patent. So they're thinking about withholding the secret source until you actually go for the patent is crucial in this market, maybe over and above elsewhere. Just I think to show the way that China has developed and the robustness now of the IP landscape, I think patents is a really good example to look at. If we look at the statistics in terms of the number of patent applications, actually China is sitting at having about 47% of those. So you can, and more than any other market out there. So you can really see that in terms of protecting IP, people are seeing a lot of value in actually going through this application process. So I think that's a good marker of how the regime has developed in China in terms of IP generally. And then last but not least, copyright. So when you have anything that's of any creative value, and this is particularly important in the healthcare space in terms of software that might go behind medtech products, any sort of AI softwares and tools that you're looking at bringing into the market, this is copyrightable. And indeed, China has an automatic copyright regime. But again, what is always recommended is actually registering your copyright, even if you already have this automatic protection under law, because that then gives you the evidence to show your ownership if there is any dispute at the end. So if any takeaway across any of these three types of IP, always consider filing, registering, whatever the regime is that's applicable, because that's where you're going to get the protection. So I won't go into this slide where there's a comparison between China and the UK. The slides will be shared, but the bottom line is, again, there are a lot of comparables between the regimes that we see in terms of the UK and China. So people should have a level of comfort now in terms of the protection that they have on the value that they look to bring with their intellectual property. And that is indeed mirrored in, I think, the way that IP enforcement has been changing in the Chinese market over the last few years in particular. Again, Gary alluded to it in terms of the value that's being created on the ground by domestic companies. Indeed, the government therefore has realized that IP enforcement needs to be upscaled to match be more aligned with the international market. So civil action in the courts, we now see around 77%, for instance, of foreign litigants trying to protect their IP actually being successful. So again, those horror stories of never winning in a Chinese court are just not the reality anymore. Administrative enforcement is possible, where it's a simple case, a very quick way going through the local government authorities to get goods seized, cessation of use of sale orders put in place. Where there are large-scale counterfeiting operations, and whether it's in terms of drug manufacturing or elsewhere, criminal sanctions are also available, and interim injunctions, as under common law in the UK, are also available. So that the full spectrum there is available for those that know how to use the channels in China. So to drill down a little bit closer to the healthcare sector in particular, IP is increasingly important across all the verticals, I would say, in healthcare, whether you're looking at digital health, medtech, or modern pharma with AI being used to produce personalized drugs. But IP is obviously crucial in other markets. But I would say for those that are new to the market, just appreciating exactly how your rights map slightly differently in China is fully important. Indeed, how they go across into contractual arrangements that you might have with counterparties is really crucial. There's a lot of great startups out there that are looking for partnerships with foreign businesses but understanding that traditionally, yes, maybe the Chinese contract might be 1 or 2 pages, and that was just the start of the legal contractual obligations between you, but would be sort of disregarded by smaller Chinese companies. I think that sort of position is changing, and there's more sophistication in the market when you're dealing with companies, and indeed the lawyers that represent them, and getting closer to more complicated arrangements around co-development, co-ownership, and other areas. All that being said, I think the same as in other markets, because of the speed of change of technology, it's safe to say that the frameworks that we have in China, those 3 core laws that I spoke about at the top of the session, they do not necessarily cover all of the developments that we're seeing, whether it's in robotics, AI, telemedicine. There aren't specific rules for each vertical. That being said, as you can see from the right-hand side of the slides, the government is very consciously trying to come up with more specific legislation to give more protections, both for domestic or foreign players around internet diagnosis, internet hospitals, etc. But there is still a gap. So again, understanding how what you're used to back in your own market, how that maps into China is an important exercise to go through. And AI is a great example of that, where we don't have a PRC AI law at this stage, but obviously there are great advances in AI happening. We have obviously the geopolitical tensions behind it. But in terms of what is happening on the ground, there's a lot of potential for some great IP in the AI space, but no specific legislation. So again, understanding when you can patent AI, maybe not when it is just an algorithm or a piece of computing code on its own, but when it's combined potentially with a bit of hardware, then that can be patentable in the Chinese market. So again, working through that with internal and external legal teams is really important in this area. Some other trends just to pick up on in terms of the laws around the IP in China and in healthcare. It's been really interesting to see how, particularly where more personalized medicines are coming into the market. It mentioned before in terms of just the manufacturing footprint in China, obviously, and the amount of medicines that are being rolled out here and potentially for export. Real trend towards more patent litigation in the market. The courts are more sophisticated in this area. But then there's question marks on the commercial side versus the legal side, again, as to when do you open up the secret source to a patent application. You have to disclose the technical details to obtain a patent, or do you keep it under lock and key and protect it through contractual rights and obligations rather than some sort of registration. So a lot of businesses that we work with toy with that sort of juxtaposition of positions initially when they come into the market. And a lot of crossover in terms of legislation between healthcare, IP specific legislation, but more and more particularly as all sort of subsectors digitalize with data legislation. People might have seen in the news yesterday an announcement from the 2 sessions up in Beijing, the creation of this new data governance ministry. The prevalence of data within this sector should not be just ignored in terms of cross-border data transfers, when data has to be secured to a certain level, and healthcare data, as you could imagine, is seen with a higher level of sensitivity in China as for other markets. So again, understanding how your products use and services use data, and that fits in with the regulations is just as important as the core IP laws, I would say. So to wrap up, if I had to distill it down to anything, I would try and take this slide away. So obviously understanding the landscape is important, leaning on IP professionals in your organizations or externally, because you're not only thinking about those core IP laws, but also data laws and other pieces of legislation that are applicable in China. And it really is a scattergun approach to some of the legal regimes that actually impact on business. and doing a mapping exercise almost to understand how that differs or is similar to your own to the UK or other markets that you're already in. And that's an ongoing dynamic process. Monitoring how these laws are changing is just as important. The authorities continue to try and upgrade the business environment by bringing out more laws, more specific laws in healthcare to plug those gaps that I mentioned before. Obviously, being proactive and registering, as I said before, being first to register is so important, even when you're looking at softwares, AI, registering copyright for evidential purposes is really important. And this will be part of quite likely an international IP protection program that you have, making sure that you know when registrations are coming up to deadlines, renewing them, making China part of that dynamic and process is really important. I think Rosie from Control Risk will talk about, probably in a bit more detail, actually understanding those business partners that you're looking to work with, whether it's in a JV situation, whether it's a distributor, but actually understanding the trustworthiness, the credibility, even the solvency of those that you might be sharing your IP with is really important. Doing a transfer versus an assignment and the different levels of protection only goes so far if the company that you work with will eventually go insolvent and the IP will be at risk there. And last but not least, actually confronting any IP infringement that you come across, actively monitoring the market, using the tools that are there. For instance, Alibaba, which is and Tencent platforms that are becoming such a big platform for selling drugs or getting services. We really see these market leaders in trying to put themselves out there as champions of IP protection, champions on Taobao of takedown where there are infringers of IP. So use the tools that are available to you, these enforcement channels that I mentioned, through the courts, through the local government agencies, through the customs, if it's an exportable good, for instance. So do be aware of the full spectrum that is there to protect you. That is all I wanted to say during the presentation. The slides will be sent around, and there's some more details about what we do as an organization here in China, so I won't bore you with those details. To the extent that there's any time for Q&A, happy to take some questions now, but I know we're tight on time, so my details are in the first slide if people want to ask me questions offline afterwards.
Lovely stuff, Alex. Thanks. Think real interesting for kind of overcoming some of the previous conceptions of China as a scary place for IP. So really appreciate you sharing. I think I'll have time for one question. For startups, what practical steps can they take without hiring a law firm, or maybe a better question is at what point do they need to consider legal advice?
Yeah. It's a great question, very valid, and one we see quite a lot. And I think Gary mentioned before, whether you go through the DTI, other arms of government, there are resources out there that can give you a steer when you're coming into the market. There are obviously materials out there online which are free to access as well, but using chambers of commerce as well, and getting getting advice through people that have already come into the market in healthcare and sort of adjacent sectors is a really good way to access knowledge on a pro bono basis, if you like. At the end of the day, when you need to go and do registrations, there will be a cost, but there are local IP filing agents that, for instance, that do this as their bread and butter, and a lower cost, for instance, in using a strategic law firm, for instance, like ourselves. So there are horses for courses, to use that phrase, depending on what you need to do. But I think I would always recommend those that come into market, look for those resources like the DTI, the British Chamber in Shanghai, where myself and a number of other speakers are there and available to answer these sort of questions for those that are inquisitive.
Sure, cool. And I think, as you mentioned, a number of folks on this webinar and across the series are affiliated there, and I'm sure available to provide some advice. So good answer, appreciate it.